Good morning, ladies and gentlemen. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the courtroom 304, and this is Tuesday. So we have jail arraignment, jail cases for arraignment and for revocation of probation. We also have a separate arraignment calendar, and I'll call those calendars. Trying to find. It's not loading. Hold on just a second. There we go. All right. Jail and probation calendar. The arraignment calendar is, we'll call the arraignment calendar first. And let's see. And then we have a criminal motions calendar at 1 p.m. today. So, all right, the arraignment calendar. First case on the calendar is Leslie Marie Acosta. This is a ticket. Leslie Marie Acosta, a TK.
She's present in the courtroom.
All right, come on up, Miss Acosta. So, ma'am, you have a failure to yield the right of way. You can hear from, if you wish to represent yourself, you can do that, or you can have an attorney represent you. Which would you prefer? If you represent yourself, I'll have the state announce what they wish to have as a recommendation in your case. And if you have an attorney represent you, they'll speak with your attorney.
I would like to have my attorney with me.
Okay, how old are you, ma'am?
I'm 20.
Woo, yeah. Mr. Taylor or Mr. Lynch, could you speak with Ms. Acosta? So, Ms. Acosta, the penalties when you have a conviction for a moving violation can be kind of severe for someone who's under the age of 21. Until you're 21, you only need 6 points on your license to suspend your license. The suspension will be a 6-month suspension, which is longer than if you were 21 or older. And also it's a hard suspension, which means that you wouldn't be able to get a permit to drive to school or work. All right, so if you have a seat, one of the attorneys is going to speak to you about your case, okay? All right, thank you. Keith Dante Barnes.
Good morning, Your Honor. That's my case. He's online. That's going to be a plea this morning to count 2, I believe, the speeding charge, a plea of nolo.
Right, I'm ready whenever Mr. Barnes is. Mr. Barnes, can you see and hear us? I see him on, I see his name on the screen. Keith Barnes, sir, can you unmute and show us video? I'm going to send you a message that usually kind of helps with if you're having technical difficulties.
Okay, I'm here.
There you are. All right, now I'm going to send you another one that helps you start your video.
Okay, can you see me now?
I see you and I hear you. All right, so Mr. Smith, are you ready?
Yes, Your Honor.
All right, Mr. Barnes, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. So, Mr. Barnes, you're before the court on State of Georgia versus Keith Barnes, Keith Dante Barnes, 2022 R00971. So, Mr. Barnes, you're before the court for reckless driving, speeding 35 plus miles an hour over the limit, and too fast for conditions. You're represented by Attorney Vernon Smith, who's with you here on the video call. Mr. Smith has indicated that you wish to enter a plea of nolo to count 2, speeding 35 plus miles an hour over the limit. Mr. Smith, is that correct?
That's correct, Your Honor.
All right. So, sir, by entering this plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. Barnes, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
I do.
All right, factual basis and recommendation, please, Ms. Hagler.
Yes, Your Honor. On or about December the 7th, 2020, Officer Tybon, T-Y-B as in Victor, A-U-G-H-N, McCullough, M-C-C-U-L-L-O-R, initiated traffic citations to the defendant for reckless driving, speeding 35 miles per hour over. The defendant was clocked going 108 miles per hour in a 65 mile per hour zone. And also too fast for conditions. These incidents did take place in Clayton County, Georgia. You know, at this time, the state is going to now cross counts 1 and 3. For count 2, 12 months to serve, 2 days, community time served, balance suspended, a fine of $500 to be suspended. And the defendant has already completed the defensive driving course. We do have a copy of that certificate, and he is NOLO eligible.
Ooh, Mr. Barnes, that's an amazing, amazing deal. Mr. Smith, anything on behalf of Mr. Barnes?
Your Honor, we would ask that you accept the recommendation. It is a situation where he did spend a couple of days in jail for not necessarily for this. I think he was ticketed for this, but he missed a court date based on, he had given the clerk's office his change of address. It didn't get updated in the system. I think he had done it several times, and he
Yes.
still hasn't gotten notices on things, but, and he has spent some time in jail. He's done his driver's improvement class, and I don't think you'll be hearing from him again.
All right, Mr. Barnes. Sir, driving is a privilege, but it's also something that we have to take very seriously, because if you hit somebody other car at 35 miles per hour, do you understand what that car is going to look like and what you and the other person are going to look like? Have you
Yes,
ever
ma'am.
seen high crashes on the internet?
Yes, ma'am, I have.
Other people on the, and I will tell you from personal experience, when I look in my rearview mirror and somebody's coming really fast and they're doing that thing where they're zigzagging through the lanes, I panic. And so I don't know whether to stay where I am, go to the left, go to the right, and you're going to get somebody who's going to move into your lane when you thought they were going to stay in their lane because they panic. And so that's going to cause loss of life. I just want young people to start realizing that it doesn't matter if you can go 200 miles an hour. You don't need to go 200 miles an hour. If you want to drive fast, they have race tracks around here that you can rent. They have safety features. You can go and get one of those driving experiences. But 75, 85, 285, that's not an open track. We clear?
Yes, ma'am.
So I'm going to accept your plea of nolo. I'll sentence you to 12 months to serve 2 days, credit for time served. The balance will be suspended. The $500 fine is suspended, and you will have credit for taking the driver improvement class. My understanding is that you have already produced that proof of that class to
Yes, ma'am.
the office. Okay. All right. So, Mr. Barnes, I'm sure I won't be seeing you again.
No. Thank you.
All righty. Take care. All right.
Mhm.
Mr.
Thank you, Your Honor.
I'm sorry, anything else, Mr. Smith?
No, Your Honor, can be excused.
All right, yes, Mr. Barnes, you can be excused, and please spread the message. Don't go as fast as you can just because you can. All right.
Okay, thank you. Mhm.
All righty. Next on the calendar is Gregory Errol Brown. Gregory Errol Brown. Gregory Errol Brown.
Judge, if I
Yes.
may, so Mr. Brown was on the Zoom meeting when the court, we tried to put him in multiple breakout rooms. I don't believe we ever got contact information from Mr. Brown. And so I'm not sure.
Hey, wasn't he supposed to come in?
I think that was an announcement made by the court on that day. I just don't know if I just can't confirm that he ever got it.
Well, can somebody chat him that he needs to come in? Because we're not doing this thing where we have to worry about his Wi-Fi and all of that today.
And I understand. So the thing is that I don't believe we ever got his contact unless he's on the call now. That's how I was trying to track down his information yesterday, and I was unsuccessful. So I'm not sure if he's here, but
Okay, well, if he's not here, then he's gonna get a,
Judge,
huh?
I understand that you'd be likely to issue a bench warrant. I think he just had his bench warrant called, and because he did report to the last court hearing, if the court would consider maybe giving him a one-time continuance so we can try to find out his contact information from another way, because I just think we never actually, no one from Lister and Holt actually spoke to him on the last calendar, and I don't think we ever got his contact information, so I just didn't want him to.
All right, well, y'all work on that until the end of this calendar, and then we'll revisit it, okay?
Sure.
All right. All right, the next is a petition for Kathy, Thomas Henry Kathy.
Your Honor,
Oh,
Mr. Caffey's an active inmate.
Okay.
He's received new charges that haven't been accused yet. He's here for the violation of probation.
okay, so we'll do him on the jail calendar. Is that okay?
That will be fine, Your Honor. Thank you.
All right. Next is Stephanie Nicole King.
Yes,
Yeah.
Ms. King's online. And
All right.
Yes, ma'am.
So what are we doing in Ms. King's case? She has improper turn, improper signal, drug objects, and marijuana 1 ounce or less.
Your Honor, I believe counts 2 and 3 are to be null prost. We intend to enter a no-low plea to count.
All right.
Return.
Ms. King, I need to see you, ma'am. I'm looking at a garage or something.
Yes, ma'am. I'm sorry. My speaker is broken.
No, I hear you just fine. You
I'm
just had the thing turn funny.
Oh, yes, ma'am. I'm holding the phone to my head so I can hear you better because one side of my speaker is not working, so I can hear half as good.
Okay, raise your right hand for me.
Yes.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
Okay, you can put your hand down. You're before the court on case 2021 CR 06894. You're represented by Mr. Taylor with the law firm of Lister, Holt, and Dennis. You're
Yes.
entering a plea to count 1 for improper turn, improper signal. Did you say no-low, Mr. Taylor?
Yes, Your Honor.
Counts 2 and 3, drug objects and marijuana 1 ounce or less will be no cost. By entering the no-low plea, ma'am, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Yes, ma'am.
All right, now you can hold it to your ear because the solicitor is going to give the factual recitation, okay?
Yes, ma'am.
Thank you. Go ahead, ma'am.
Thank you.
Yes, Your Honor. On or about November the 26th of 2020, pursuant to the probable cause affidavit from Officer J. Robinson, Officer Robinson did observe the defendant operate a white Nissan Sentra on the Georgia roadways. The defendant was observed conducting improper lane change. A traffic stop was conducted at Terra Boulevard and Jonesboro Road in Clayton County, Georgia. During the officer's investigation, he smelled a strong odor of suspected marijuana. The defendant was detained. Based on a search of the vehicle, Officer Robinson located a clear plastic bag of suspected marijuana, 3.8 grams, inside the center console. Your Honor, at this time, he also located a black and color digital scale inside the glove compartment. For count 1, it will be a fine of $100, and counts 2 and 3 will be not crossed.
All right, Mr. Taylor, the fine is $100. Does your client need more than 30 days to pay?
Ms. King, can you pay that immediately or do you need more
Ms.
than 30?
Ms. King, I can give you up to 60 days. Because you're not at the courthouse, I'll give you 30 days automatically. Did you need more than 30 days to pay? And it's a $100 fine, but the total after the surcharges is $151.50.
All I need is 30 days.
All right, ma'am. You can, what the last thing I need you to do is to send your email address to our court clerk through your chat function.
Okay.
Do you know how to use the chat function?
Yes, ma'am. I'm
Okay,
doing it
so
right now.
when you do it, you're looking for clerk. Don't send it to everyone. Click on the name in blue and put clerk Terrell Holcomb. That's our clerk for today. And when you send her your email address, she's going to email you back your sentencing sheet that gives you the exact date by which you should pay.
Yes, ma'am.
Ms. King, is your email address still your Yahoo address?
Yes.
Your Honor, I'll send that email address to.
All right. So Ms. King, Mr. Taylor's going to send that for you. Just remember, you have 60 days to get it all done. I'm sorry, you have 30 days to get it all done. And you should check your email address sometime tomorrow. Check your spam folder if you don't see it immediately.
Yes, ma'am.
All right, ma'am. Thank you. Be safe.
Thank you.
All right. Take care. All right. So I believe we have, that concludes the arraignment calendar. So Acosta is speaking with Lister Holton Dennis. Do you have any announcement on that?
Judge, I wanted to see if I could have a quick breakout room with the state to ask
Okay.
the state to consider whether they would take anything into consideration, such as potentially a defensive driving course.
Okay. And then Kathy's an inmate. Brown, we haven't heard from, so we're considering that till the end of the calendar. Ms. Hagler, Mr. Lynch, I'll put y'all in a breakout room now before we switch over to the jail calendar. And then once y'all come back, we'll go ahead and switch over to the jail calendar.
Okay, thank you, Judge.
All right. All right, you all are in breakout room number 1.
Okay, thank you.
Judge, I do have an announcement on Miss Acosta or Acosta.
All right, what's your announcement?
Judge, after speaking to the state, we would request that it be reset for 2 weeks for Mrs. Acosta to take a defensive driving course, and the state would take that in consideration in their final disposition of the case. If Your Honor.
No, that's fine.
Thank you, Judge.
All right, just impress upon Ms. Acosta that driving is a very serious matter.
Yes, Your Honor. And do we have a specific date we want to go ahead and tell her now, or are we just?
Ms. Val, do we have a date for this?
We have the 8th of October. You need longer than that?
No, that'll work. 8th of October?
Yes, that will work for Ms. Acosta. She'll make sure to get it done. A DDS approved defensive driving course. This has to be the part. Yeah, DDS. And Judge, I do have one more announcement.
Yes.
Just kind of miscellaneous. There's a Mr. Frank Hogan in the audience, or in the
Mr. Who?
Frank Hogan. He was here last week. He's represented by Chris Tolles. He indicated that he thought he had court today and that he wanted to make sure that he didn't get bench warranted because maybe there was some issue. He just stepped out to go to the restroom. I'll have him address the court. I'm not sure if he's confused about the court date or what's going on with it.
Can somebody look up Mr. Hogan's case and find out when he next has court? Because I don't think it's today.
Yeah, I didn't think so.
It's
either.
not today.
Yeah.
Yeah, I think that communication, but I think that it was supposed to be on today's calendar, but Mr. Toll sent a conflict anyway. So do you want to reset to the October 8th calendar?
When is Mr. Tolles going to be available since we're working on his schedule?
That's a beautiful question, Judge.
Ms.
But I'll-
Val, Judge. Mr. Hogan
Yes.
is already on the 10-8 calendar. Or arraignment.
Okay, so
He's already.
Okay.
Thank you, Ms. Arnold. Does Mr. Tolles know he's on the 10-8 calendar?
once again, we'll send Mr. Toll's notice.
All right.
No.
Mr. Lynch? Mr. Lynch?
Yes, Your Honor.
When Mr. Hogan comes back, just tell him that he and his attorney are on the October 8th calendar, that he is free to go at this time, but he's on the October 8th calendar, and it would be helpful if he reminded his attorney of that.
Okay, October 8th, is there a time?
The 10 a.m. calendar.
10 a.m. Absolutely. I will tell him that, Your Honor.
Thank you.
Thank you. We need y'all's contact information just to make sure that
It's magistrate court all over again, Ms. Val.
October 8th, obviously, you're gonna have to be.
All right, so we're gonna go to the jail calendar at this time.
Are the inmates in the booth now? Yeah.
First case on the jail calendar is a petition, Aglu.
Well, who do you need? McDowell? I'll let McMichael.
Am I muted?
No, Your Honor, I can hear you.
Okay. First case on the jail calendar is Aglu. Rashard Terrell.
Judge, my understanding is he did not ask for an attorney on that, and I think he has an agreement with Mr. Austin. I'm not sure.
Okay.
He did, Your Honor.
Next case is Chris Julius Irvin Jr.
That's on the state's motion to revoke bond of Mr. Irvin.
Okay.
Yes, the state is ready unless the defendant wants to resolve the case today, but the state is ready.
Mr.
I
Irvin,
believe I sent you an offer on that, Attorney Lynch.
I may have seen it. I saw the previous offer, but
I sent you an updated one yesterday.
so I've had him, he's not ready to resolve his case today. He may, but we're ready to go forward on the motion.
Okay. So the next case is James Harvey. That was Mr. Ibikwe's case, and it's closed as of January, but he's on a petition. Has he requested assistance?
I'm sorry, Your Honor.
James Harvey, he initially had Ibikwe, but he's on a petition. So has he requested
I have not spoken to him. I'm sorry, Judge. When I saw, I thought he was represented by a private attorney. I did not speak to him.
Yeah, I think since then, Mr. Abikwe has either come off the case or doesn't know about the case.
Okay.
So if y'all ask him if he needs, then fine. McDowell, Devon Devon McDowell.
Mr. Taz is going to address that. Mr. Taylor, sorry.
All right.
Thank you, Your Honor. I need to speak with Mr. McDowell this morning. I'd met with him previously before we had the Senate's recommendation from the state.
Okay.
Relay that offer, but it is an abandonment case, so it's a little odd situation. I don't know if he wishes to contest the abandonment or take the recommended sentence, which is to get out and begin performing or making additional child support payments.
Well, talk to him.
I absolutely will. I wasn't sure, but I had to get that information from the solicitor first after I had previously talked to him.
Okay, thank you. Mark Tavius. Oh, I'm sorry. Go ahead.
The next one is Martavius McMichael. I also need to speak with Mr. McMichael because I learned new information about his case since I spoke to him on Thursday.
Okay.
Apparently, he has two separate cases, one in Superior Court when we were under the mistaken impression that that Superior Court case had actually been transferred to state court for battery family violence. He has another case called for an ag assault. It appeared that the ag assault had been reduced to a battery family violence. However, that was not the case. There were two separate incidences. So I need to talk to him to see how he'd like to proceed with that new information.
Okay. Next is DeMarcus Zashawn Smith.
Judge, that'll be a plea today.
All right. James Spence.
Mr. Spence?
Mm-hmm.
Not guilty. This was, at this time, it's not guilty, Your Honor.
Okay. Mr. Spence can go back. Bruce Thomas. So Bruce Raymond Thomas.
Judge, looks like he's not, we haven't been appointed and he is just in for, he's already resolved his case. He's just in for a SSD. So I'm not sure if you just wanted to bring him out and.
How long is he? Let's find out how long he's been in. And then Ms. Powell, can we do a modification for Mr. Bruce Raymond Thomas Jr.? If he's been in for more than 2 days, then he gets a modification credit for time served. In lieu of,
I know he's been in over the weekend at the very least.
yeah, so we'll do a modification on his.
Judge, modifying to suspend the order or to suspend his sentence?
I'm sorry?
Are we modifying to suspend his sentence?
Yeah, you know the SSD modification orders?
Yes, ma'am.
Yeah, you can just go ahead and modify it to time served, credit for time served in lieu of fines.
Yes, ma'am. Which defendant is this?
This is Bruce Raymond Thomas Jr. He's on the jail calendar. And he's 2023 TK 16202.
Got it. I'll get that to you.
All right, thank you, ma'am. And then we can go ahead and get that done. Eureka Marcel Whitaker.
Judge, that's going to be a plea today. We'll submit an appointment order. It was previously a public defender case.
Okay.
But he'll take a negotiated plea today.
All right. And Wilson, Joseph Demond Wilson. That was closed, but he's back for a petition. We just did that.
So I did bring to Mr. Wilson the recommended sentence from the probation office, and he's willing to accept that, which I believe was 90 days to serve and close the case.
Okay, so so this is what I have on announcements. So then we still have Brown. I mean, it's not Brown, Caffey. That's also a petition.
Correct.
Agwu is a petition. Irvin is a motion to revoke. Harvey is a petition. McDowell and McMichael are both you're still talking to them. Smith.
And Your Honor, if I may, from McMichael, this case was actually transferred to Superior Court. The defendant did plead guilty to a battery of family violence in 2013. So we won't be able to do anything on this case because it has been transferred.
The McMichael case, the current one, let me just be sure,
Yes, Your Honor.
204 CR 07584. That's the one I signed?
Yes, Your Honor. Mhm.
Okay, so McMichael is gonna go back because his case is now in Superior Court.
Yes.
So that's one off. All right, so Smith, we were still trying to figure out if he needed counsel. Is that the first?
Smith is going to be a plea today. We got appointed. You did appoint us to. Mr.
Okay. I like two Smiths. All right, so.
We're talking DeMarcus Smith will be a plea today.
Yeah, I think I wrote it twice. Spence is a not guilty, so Mr. Spence is gonna go back. Thomas is a SSD modification. I'll sign that as soon as I get it. Whitaker is a plea, and Wilson is a petition, stipulate and agree. So I'm ready. Let's go ahead with the motion to revoke bond, if that's okay, and then you all can, then we can go down the list for the rest of the stuff, if that's fine.
Yes, Your Honor.
If we have any outside people who are here to testify on the motion, I want to go ahead and get that done.
And just give me, the deputy's going to get Mr. Irvin out here.
All right, thank you.
So you can come back on October the 8th at 10 a.m. So she just made an announcement and told me to relay it to you. Okay. And what happened is your attorney filed a conflict. Yeah. So he had a conflict for today. You were told to come back here today, so you can get that correct. However, Mr. Coles ended up filing a conflict. And so it was placed on October the 8th at 10 a.m. for you to come back with Mr. Coles. And just said, if you could please make Mr. Coles aware that, or try to
ask her real quick. I need paperwork so I can do highlight. I keep coming back to the court and missing work. I just need to ask her. That's why I came up here. Go downstairs to the second floor. But I came here to talk to her. I'll find my lawyer right now. Right now, she's not going to talk to you. I had court today. You don't have court today. He just gave you court today. The judge. I'll talk about that. All right. I can't stop the court. I've been going for 10 months.
Yeah. All right. You can stand right next to me, sir.
This is State Court of Clayton County. This is a motion to revoke bond brought by the Solicitor's Office on behalf of the people of, this is case 2024 CR 00811. Mr. Chris Julius Irvin Jr. Is before this court on battery with provocation count 1 and simple battery count 2. Mr. Irvin is represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is with him. Mr. Lynch, are you and your client ready for the motion for to revoke?
Yes, Judge, we're ready.
Is the state ready?
Yes, Your Honor.
All right, just one moment.
Yes, Your Honor.
That's in this case.
So he doesn't even know that's what I have to tell him, like, why is it that I have to tell my lawyer? I want to fire him so I can get the case over with. So can you relay that to the judge that I'm going to fire my lawyer, my company? I had a court case there. I got it from my bondsman. So I'm on the calendar.
Let's get through this motion and I'll tell her you're trying to talk to her.
All right, I'm back. Thank you. All right, ready to go forward. The state may call its first witness.
Yes, Your Honor, before I call out our first witness, I'd like to court to take judicial notice regarding the order for bond that was signed by Judge Stephen N. Knights, Knights Jr. on May 3rd of 2022. Pursuant to the order for bond, the defendant was to stay away from Marcus Wiles and to not violate any laws while on that bond. At this time, I'd like to call Detective Jason Gant.
So first, the defense would object to the state taking, or the court taking judicial notice. And also, what was the name that you stated he was to stay away from?
It says Jamarcus Willis. I'm sorry, I missed.
The victim in that case. Okay.
Yeah, I'm sorry, I misread the handwriting.
Jamarcus Wiles?
Willis, I'm sorry.
Willis, I'm sorry. Okay. All right. So what's the issue with me taking judicial notice of the magistrate court's order?
Well, I mean, I just think that judicial notice is for issues that are not reasonably in dispute. And I would just argue that the state would need to present evidence that that bond order exists.
You got a copy of the
Yes, Your Honor.
Copy of the bond order?
Yes.
All right, share screen. No problem.
Try to pull it up. Give me 1 second.
No problem.
Let me get with Miss Arnold to see if she can pull up for me. Okay, 1 second. And 1 second, Your Honor, while I'm working on getting this.
No problem.
And Your Honor, Ms. Arnold is sharing her screen now, if you can see it.
All right, Mr. Lynch, can you see it?
And again, this was emailed to him, so he should already have all of this.
All right, so the court has recognizes that there's an order for bond from the magistrate court, former magistrate Judge Stephen Knights Jr. signed this on the 3rd day of May 2022.
Thank you, Your Honor.
Okay. Court
I'm
also
sorry.
recognizes the stay away petition for Jamarcus Will. All right, proceed.
Thank you, Your Honor. Detective Gant, can you please unmute yourself and raise your right hand? Do you swear or affirm that the testimony that you're going to give will be the truth to help you God?
I do.
Thank you. You can please lower your hand. And can you please state your first and last name for the record?
My name is Detective Jason Gant. I work for the Clayton County Police Department. I've been working for the Clayton County Police Department since 2018. I'm a detective in the Major Felonies Unit and have been in that position since 2021.
Okay. And were you working, and you were working with the Clayton County Police Department on March the 30th of 2023?
Yes, that's correct.
Okay. And what are your duties and responsibilities?
So I am a detective on the Major Felonies Unit. I primarily work crimes against persons. So this would be murder, rape, armed robbery, ag assault, serious crimes with a person victim.
Okay. And were officers dispatched to 524 Flint River Road on that day?
Yes, that's the Shell gas station, correct?
I'm sorry, say that one more time.
The Shell gas station, yes.
Okay. And what county is that gas station located in?
Clayton County.
Thank you. Let the record reflect that venue has been established, Your Honor.
Record shall reflect.
Thank you. And what was the nature of that call?
So that call was a shooting call. It had started as a armed robbery that turned into a shooting. And then the victim of that robbery died of his gunshot. So it became a homicide case.
And during your investigation, did you speak with any witnesses?
I did speak with witnesses, but the bulk of the investigation came from the security camera footage from the gas station. The gas station had very high quality cameras that recorded.
And what did you observe on the video footage from the gas station?
All right. So in the video footage, we see a white Chrysler come into the parking lot. Mr. Irvin gets out of the driver's seat of the white Chrysler. He comes inside the store. He waits in line. He goes up to the cash register. After a moment at the cash register, he goes back outside to the white Chrysler. He then pumps gas. Another young man who we identified as Mr. Muse gets out of the passenger seat. They speak outside the car for a while and then get back in the car. After they get back in the car, a red pickup truck being driven by Mr. Shannon Watkins, the victim in this case, pulls up. Mr. Watkins gets out of the car and goes inside the store. Mr. Watkins is carrying a pistol and a holster on his right hip. It's open and visible. After Mr. Watkins goes inside the store, he starts picking out drinks from the coolers. After he comes in, Mr. Irvin gets out of the driver's seat. Mr. Muse gets out of the passenger seat. Mr. Muse leaves the front car door fully open. He comes around and gets in the driver's seat. Mr. Irvin then comes into the store and gets in line behind Mr. Watkins. When Mr. Watkins goes up to the cash register and leans in to go pay, Mr. Irvin snatches the gun out of his holster. Mr. Watkins turns around and the two of them begin to fight over the gun. They are in contact with each other, fighting, wrestling over the gun, and go out the door. Once they go out the door, they start fighting there on the sidewalk in front of the store. Mr. Watkins slams Mr. Irvin to the ground. The gun that they were fighting with slides across the ground. Mr. Watkins then stands up and starts to run away. As he runs away, Mr. Irvin draws a gun and starts firing the gun at his back as he's running away. And Mr. Muse comes running out of the Chrysler, firing a gun at Mr. Watkins. Mr. Watkins collapses to the ground. Mr. Irvin gets up, runs, and jumps in the driver's seat of the vehicle. Mr. Muse jumps in the passenger seat of the vehicle, and they speed off. Mr. Watkins was transported to the hospital, and he died of his injuries. He was hit numerous locations all over his body with handgun rounds. All of the firearms involved were .40 calibers, so we don't know whose bullet did what, but he was hit multiple times. Okay. So from there, we see the white Chrysler pull out of the parking lot onto Flint River Road. We get the tag number of the vehicle from a flock camera on Flint River Road. From there, we get the registered owner, a female. We start looking at her family members to see who could have been driving the car, and we pull up the driver's license photo of Mr. Chris Irvin. When we see his driver's license photo, it's immediately recognizable as him from the video. The video inside the store is very clear. You can see his face very clearly. We identified it as him. So I took out arrest warrants for Mr. Chris Irvin. The arrest warrants went to the sheriff's department. The next day, they find the white Chrysler at Mr. Irvin's home. They speak with his family, say we have arrest warrants for him, and then he comes and turns himself in.
Okay, thank you, Detective Jason Gant. And so the person that you saw on the video, do you see him in the courtroom today?
Yes, I did see him.
Can you please identify what he is wearing and where he is standing?
He is wearing a red jumpsuit with a white shirt, and he is standing behind his defense lawyer.
And that would be Mr. Chris Julius Irvin?
Yes, that's correct.
Thank you. Let the record reflect that Detective Gant has identified the defendant in this case, Your Honor.
Record shall reflect that.
And during your investigation, were you able to locate any shell casings at the scene?
Yes, there were numerous .40 caliber shell casings at the scene.
And you stated that you did issue arrest warrants. What were the arrest warrants issued for? What charges?
It would have been aggravated assault, felony murder, and armed robbery.
Okay. Thanks, Your Honor. Further questions for Detective Gant at this time?
All right. Mr. Lynch?
Thank you, Mr. Gant. I do not have any questions for you this morning.
Okay. Any anything else at this time for Detective Gant, or can he be excused?
Nothing further from the state, Your Honor. He can be excused.
All right. So Detective Gant, thank you. You're excused at this time if you wish to leave.
Thank you.
Thank you, Detective.
Ms. Hager, do you have additional witnesses or evidence to present?
At this time, the state rests, Your Honor.
All right. Does the defense have evidence or evidence or testimony that they wish to present at this time?
Judge, we're not going to present any evidence in this matter today.
All right. Argument, Ms. Hagler, Mr. Lynch.
Yes, Your Honor. At this time, the state would ask that you revoke the defendant's bond. Again, he was given a bond order that was dated on March 3rd of 2022 and signed by Judge Stephen Knight. You did hear from Detective Gant, the new incident did occur on March 30th of 2023. He testified that he did, based on the video evidence from the Shell gas station, he was able to identify and link the defendant to the new charges. Arrest warrants were taken out according to Detective Gant, and according to him, the defendant did turn himself in. And so for those reasons, because the defendant has picked up additional charges while out on bond on the case that's on the calendar, then we will ask that you revoke his bond until his jury trial. Thank you.
All right, Mr. Lynch.
Judge, Mr. Irvin has not been outside of the Clayton County Jail in quite some time. He has announced ready for trial. He also has an attorney representing him on the case that was referenced by Detective Gant. He has a bond on that case, Judge, and pretrial detention is not meant to be punitive. If he is able to make that bond in that case, so revoking his bond in this case would be especially punitive because it could have the effect of blocking him from being released if he is able to make the bond on the felony case, which, him working with his attorney. So that would be especially punitive in this case for Mr. Irvin. Again, this incident he's presumed innocent until proven guilty. So we ask the court not to revoke his bond on the misdemeanor case pending before your honor. He and we're announcing ready for trial. Well, we've announced ready for trial in that case. We expect it to be tried in the next trial period or soon thereafter.
All right. So while motion to revoke bond, the actual act of revoking a bond is not meant to be punitive. It is meant to be protective. The whole point of having a bond is to keep the person from committing another violent act, because most of the time, if a bond condition is set where someone is named, it is to facilitate the cessation of violence and to make sure that witnesses aren't tampered with during the time before the case is resolved, as well as discouraging someone from committing serious misdemeanors or felonies. And essentially, the whole point of bond is not so much about misdemeanors, but the focus is on that this person will not then go out and commit, as in the Ayala factors, a serious misdemeanor or felony. And it appears from the testimony of the detective that there is probable cause and possibly good evidence to suggest that Mr. Irvin did exactly that which the bond was supposed to deter him from doing, which was to go out and commit an act of violence, and in fact, not just a serious misdemeanor, but a felony or several felonies. And so at this time, the court is going to revoke the bond of Mr. Irvin, even if he were to make, which based on what I'm hearing, I know that he is entitled to bond if not indicted within 90 days. But even if he were to make that bond based on whatever decision that judge makes, he is going to be retained in court in the Clayton County Jail until such time as this case before me is tried and resolved.
Yes, Your Honor, for the court's information, he was indicted. I have a copy of the true bill.
Okay.
So he was indicted. Yes, Your Honor.
All righty. So, Mr. Irvin, just don't know what to say about this. Please don't say anything, but I just don't know what to say. I hope that if there are any individuals watching that really just discourage senseless acts, because an orange jumpsuit or a red jumpsuit in prison time, not jail time, but prison time is not what any of us wish for young people. So, Mr. Irvin, you can go back with the sheriff's office.
Thank you, Judge.
All right. Are we ready to go forward on the remainder of the cases, or do we need some time?
Judge, I had relayed your message to Mr. Hogan. He has asked to address the court
Mr. Hogan, come on up.
How you doing, Judge? Thank you
I'm
for
good,
letting
Mr. Hogan.
So I apologize again. I stepped out waiting for the
That's
court
okay.
date again. I need this to be over with, ma'am. I got the money. I need paperwork so I just want it to be behind me. I truck drive. I'm missing work. I'm moving things around to try to make these court dates.
I got you, Mr. Irvin, but it's not me.
No,
It's,
watch this. If I have to fire, if I can't take care of it today, this is what's gonna happen. I'm gonna fire my judge when I leave the office. I'm gonna fire Chris and then my attorney. I'm just discombobulated because, like I said, he's in Fulton County right now fighting somebody else's case, and I'm like, Chris, why didn't you tell me this? And I've been like, what are you trying to do to me? If it's just a speeding ticket, right? Why did I go to jail? Why am I paying? I lost a job. Everything's gonna go up. Even though I'm gonna not possibly have points, my insurance still goes up for the next 5 years. It's harder to get a job because this still shows up on my background. The next time I catch a speeding ticket in the remainder of my life, the state's attorney is gonna bring it up against me. So all I'm trying to do is whatever needs to be done today, I just wanna pay the fines. That's why I came up here, because last week he gave me the wrong password to the Zoom meeting. I'm not trusting him. I'm thinking he's gonna be here today. He's at Fulton County. He's gonna call me soon to tell me that I'm making a bad decision by possibly gonna fire him, when it's like, listen, I can fight this case by myself because I have the evidence that I was being chased. I have 2 defensive driving courses. I did everything that I was asked of. I tried to do the community service. I got paperwork from a reputable lady that works at an animal hospital, was letting me do it, but she says that I need paperwork from the court stating that you're required, because if she lets me in her building and I slip or get hurt, she's not going to be able to tell her insurance that she let me voluntarily do.
I got you. Mr. Hogan, it's not me. It is that you have a relationship with your attorney, and had you fired him before you walked into court today, by all means, we could move forward. But the fact that he is still your counsel of record, I can't do anything until, now let me just explain this. I'm not encouraging you to fire your attorney. That is a decision that you need to make.
I have to, because like I said, I'm sure there's 1,000 more attorneys that will want my money. I'm
Okay.
losing money by being here.
So this is the other thing. We have you on the calendar. So you weren't even, my understanding is that you may have been scheduled to come in today, but we got another leave from Mr. Tolles.
You don't tell me nothing. This is my lawyer that I'm about to fire, Mr. Tolles. I'm sorry. I just, like, when I came to the court last month, that was my first time meeting him. I didn't get a chance to even talk to the state's attorney. She's bringing up stuff. So like I said, if she wants a trial, I will gladly, I promise you, listen, please look at the case and I will gladly. If you go further into my background, I will gladly. I have the time and the money to represent myself. I won't even hire another for this. Chris keeps telling me it's just a speeding ticket. My driver's license depends on me driving semi trucks.
I got you, Mr. Hogan. I say that all the time. So
it's sorry. The thing is, I'm discombobulated too, because I keep missing work.
I got you.
To come up here to make sure I'm not going to, that last time, it was probably a clerical error. He put in the leave of absence, and I had a warrant, still a bench warrant, and I had to go spend 10 hours in Clayton County. That's the first time, and because of everything I'm going through with you guys are making me want to get into politics and change what's going on out here. You know what I'm saying? So,
and I applaud that, Mr. Hogan, because we need people who understand the system to help change the system to make it better. And I'll say that all the time. The only thing I would say is you are able to come to court by video on October 8th. Whether you're represented by Mr. Tolles or not, you can come by video and we can give you the password right now. That's not a problem.
I would still come up here. It's safer for me to come up here. I live 5 minutes away.
Oh, okay, that's fine.
It's safer for me to. I want to pay the fines today. I was given. Can I pay the court fines while I got the money?
Okay.
Next month I might not have the money in the bank account.
Okay, so just hold on, because the thing that is holding me up is I'm all fine with you firing your attorney, but I would rather him know that you're firing him before we move
Well, I was on the phone with him. He's in Fulton, so like I said, if I can be away with it, talk to the state's attorney on a private call, me and her hopefully discuss it.
Mr. Hogan, I get it.
Okay, I'm sorry.
There are rules to this, and so I understand. what the situation is with you. I get that. But there are rules to this. So the state's attorney is prohibited from speaking with you directly because you're represented by Mr. Tolles.
Gotcha.
I am prohibited from moving forward with your case because you're represented by Mr. Tolles. Now,
That's why I got the lawyer.
wait, hold on. Now, what I say to you is you are already scheduled for a hearing on October 8th. That you can come into court or you can come by video and we can resolve your case. If you wish to fire your attorney, then you need to do so prior to that and let him know you're firing him. And then we can put it on the record in court once you do that. But him just being he has a conflict that he filed with the court and he's in another court. And for you to come and fire him and then move forward with your case puts Ms. Hagler in jeopardy and puts me in jeopardy. Now, if you wish to do all of that, do it before October 8th.
Can I do it the same day if he's not answering my calls? Like basically when I wake up in the morning,
Well, I know the whole point is to let him know. So
well, exactly. He'll know before, because I'm going to find out if he's going to represent me on October 8th. If he isn't, like now, what I'm explaining to my lawyers, I've been in the dark these 8 months. You guys keep saying, listen, this isn't going to be the last time I possibly come in this courtroom. I hope it's not. I hope it's the last time, but let's be honest. You guys are drivers too. You guys make mistakes too. So that's what
it's a speeding ticket, Mr. Hogan. The only thing that makes it complicated is you have a CDL, and I always warn people that they need to be aware of how any adjudication, NOLO, plea, guilty plea, or conviction, how any adjudication might affect your ability to drive as a commercial driver.
Can I ask you a question while you're talking to me real quick? Is it in my best interest to take this to trial then, because I have evidence?
Mr. Hogan, I can't tell you what's in your best interest because that's the role of your attorney. The state can't even give you that. The only person who can tell you whether it's in your best interest is you and your attorney making this decision jointly. Like not just him saying it's in your best interest. It has to feel like your best interest. And so no matter what attorney you deal with, they can't
I get a public
make that
defender
decision.
if I fire him? Would I be able to use a public defender if I fire him?
Yeah, well, yeah, we don't have public defender. We have a law firm that we hire to do indigent defense counsel. So yes, one of those individuals, we could resolve your case with one of them if you wish.
Okay, but on October 8th though?
Yes.
Got you. Thank you, ma'am. I'll be here again. Like I said, it's just safer for me. Because what Ms. Taylor doesn't understand, last time I was doing the Zoom meeting.
No, she understands.
No, I'm talking about the Zoom thing, how I'm tech savvy.
Oh, you couldn't get on.
I'm tech savvy and I use Zoom, but for some reason I couldn't get into this Zoom meeting. And that's what I'm saying. It's like, I seen how quickly she was to put out bench warrants. And that's why it's safer. People have to understand, if you're like the other guy with the bad Wi-Fi, or you're driving and the signal goes out, it's like, look, you guys have to understand, son, if you guys, it's safer to come in the courtroom because you won't get locked up. You see what I'm saying?
As you can see with Mr. Brown, I'm trying to give him some consideration because he did appear last time, but he just had really bad Wi-Fi. Yeah, and so I'm not sure at this point.
Come up here, whoever's
representing. Yeah. So, Mr. Hogan, I tried to do the best I can.
Oh, you are. You didn't lock me up, ma'am, and I appreciate that. So, like I said, I apologize. I got the time to keep coming up here. I just prefer to get it behind me so I can start looking. Yeah,
because this is not time you need to waste.
Yeah, I already went to jail. I paid the lawyer, my insurance, everything. I'm talking about it. People don't. I'm about to go out there and advocate safe driving, you guys. All right. So next time you see me, Hagler, I'm going to be an advocator. Not only am I campaigning for Camilla or Kamala, however you pronounce her name, I'm Italian. We're not going to go there. But I'm going to advocate for safe driving. I'm going to advocate for passing along good energy. And you know, explain to
Mr. Hogan, I say to people all the time, share your experience.
I'm glad I came in here. Before I came here, I didn't know I wanted to be a lawyer. So I appreciate you guys. You told me last time I was in here, you told me all it takes is 3 years of undergraduate. I live right next to Clayton County. I'm going to go there and be in here and probably work with you guys.
Mr. Hogan,
against Ms. Hagler. I hope
I was in college. I was in college when my mom went to law school. So you can go at any time.
Oh, I know, but what I realize is you got to have the time. It's not as easy as it's what.
No, it's not easy.
As soon as you get a part-time job or you cannot be in a computer. It's not, if you have work, you can't. You can if you got help, but when you don't have help, like most people out here now, it's not back in the day where
You,
I get it.
the reason that people had wealth back in the day is because the families came together. It was barbecues and gatherings. Nowadays, there's Christmas is coming in 2 months and it doesn't feel like Christmas. So I appreciate you guys' time. I'll see you guys in October, and I hope I don't catch a case before then. So I appreciate you, Hayward.
You won't, Mr. Hogan. We'll see you then, okay?
All right, y'all take care now. Thank you guys.
All right, thank you. So AGLU is a petition. Kathy is a petition. Harvey petition. What else? Wilson petition. And then we have pleas ready on Smith and Whitaker. So did we want to go forward with the pleas first or the petitions first?
I would be ready.
I think we may have one female. Is that correct?
Judge, do we have any females? I do not believe we have any females, and we don't have any females, do we, Deputy? No, Judge, we do not have any females in custody.
Okay, so cool. That way it's less of a issue for bringing them in and out of the courtroom. All right, so I'm ready on whoever we're starting on.
Just do DeMarcus Smith.
That's fine. Bring him up.
DeMarcus Smith. Yes, please.
The phone number I had, was it different?
No, well, I talked to him yesterday, but that same phone number didn't work. But yeah. Hey, do we tell Deputy to put in James Harvey? Hey, Deputy, when you have a chance, could you put James Harvey in the booth? We can just do the plea and then do that. I was thinking we would do. Same thing we talked about. No love, fair dropping, guilty. No love.
All right, Mr. Smith, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Okay.
All right, you can put your hand down. Mr. Smith, you're before the court on 2022 CR 00656 for driving on a suspended or revoked license, count 1. No license, count 2. No tag or expired or invalid tag, and no insurance. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, count 1 will be a no-low plea.
Okay.
Count 2 will be no pros. Count 3 will be a guilty plea, and count 4 will be a no-low plea.
All right. All right. By entering a plea of no low to counts 1 and 4 and a guilty plea to count 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. Smith, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about August the 10th of 2021, while on general patrol in the area of Terra Boulevard near Flint River, Clayton County, Georgia, Officer Henry Laxon, Laxson, observed the defendant driving a BMW with no tag. There was a cardboard sign that said tag applied for. Officer Laxon was at the traffic stop. When he made contact with the defendant, he explained the reason for the stop. The defendant explained that he just bought the vehicle. However, the bill of sale showed May 23rd of 2021. Once Officer Latson checked the VIN on GCIC, NCIC, it showed that there was no insurance and that the vehicle was not registered since May 28th of 2021 from the previous owner. Officer Latson also, doing his investigation, showed that the defendant had a suspended driver's license for failure to appear on a traffic offense. Suspension date was April 24th of 2021. At that time, the defendant was placed into custody. Your Honor, for count one, the state's offer is a fine of $500 to be suspended. Count two would be non-pros. Count three, a fine of $100, and then count four, a fine of $200 to be suspended.
Okay, is the count three suspended also, or he's paying the $100?
To be it's not suspended. Count three is not suspended.
Okay. All right. So, Mr. Lynch, anything on behalf of Mr. Smith?
Well, Judge, we would ask the court to consider suspending count three. Just so he's been in custody for 14 days and he's not going anywhere at least until the 10th when he has a VOP hearing. We're prepared to accept, so we
Does
understand.
Mr. Smith have a job or?
He indicates he's currently employed, but I just,
he's what now?
He is currently employed. He informs me, but I know he'll be in custody till at least the 10th of October. So
Mr. Smith, how old are you?
23.
Right. Just mainly for logistical reasons, because if he comes back on the 10th, then I'm going to have to put him on probation, or he's going to have to get his paperwork and remember that he has 60 days to pay. I'll suspend number three also for time served. Mr. Smith, you're 23 years old, so let me impart some things to you, sir. The easy things are the things you can take care of and avoid this kind of issue. Getting your license, having insurance, having your tag, those things are the easy things. If you're driving a car with no tag, you know they got tag readers. They don't even have to see your car. Their car sees your car. If you're driving with no tag, then that leads to them stopping you. When they stop you, they're going to ask for license, registration, insurance, all of those things. Then you pick up three more charges. If you're driving, you got to have a license. Why would you drive without one? Why won't you just go down to the Department of Motor Vehicles and get a license, sir?
Ma'am, I had no idea that my license was suspended for FTA because the house that I used to stay at is still on my driver's license. I guess they sent the court date to that house.
They would do that because you didn't update so let me tell you how to never, ever, ever get an FTA again. You want to hear it? Yes. If you get pulled over, you have a supercomputer in your pocket, your cell phone. Take a picture of the ticket because everybody loses the ticket. And then calendar it in your phone. Put it on your calendar in your phone, put a reminder, and make sure you put the date, time, and place that you need to be in court. You understand?
Yes, ma'am.
If you do that, you will never miss another court date. Do you understand?
Yes, ma'am.
All right, now I don't know what else you're dealing with, but you're 23 years old, sir. An orange jumpsuit is not where you need to be. I'm gonna need you to start thinking and making some better choices in life.
Yes, ma'am.
Because I know the Clayton County Jail can't be comfortable. Now, I haven't been, but I've heard. All right, sir. You can go back with the sheriff's office. Thank you.
Thank you.
All right. Who's next?
Could you put in Harvey in the booth and then pull out Whitaker for a plea?
Your Honor, I do have an announcement.
Yes, sir.
Mark Tavius Michael.
Yes.
Not guilty.
That my understanding is they transferred it to Superior Court.
Yes, Your Honor.
So I don't know that a not guilty in this court is going to make a difference.
You won't, Your Honor. Thank you.
May I ask the basis for transferring to Superior Court?
Yes.
Yeah.
I'm sorry. Go ahead. The defendant has a prior battery felony balance in which he pled guilty in 2013.
Thank you.
You're welcome.
Stand
All
right
right, so I just signed the SSD modification for Mr. Raymond. So Raymond can go back, and I sent it over. I sent it back to Miss Val and Miss Holcomb and Miss Powell.
Who can go back around?
Raymond.
Let him know he's getting out. Raymond. It's Bruce. It's Thomas Bruce, right, Judge?
Bruce Raymond Thomas. I'm sorry.
Thomas, right? Yeah.
Okay. So I got Michael can go back. I got Thomas can go back. Smith can go back.
The guy who just took a plea, Smith, can go back. Yeah.
What about Urban?
Urban can go back.
James McDowell. What about Agu?
No, he's gonna still come out.
And then Wilson.
Wilson still needs to stay up.
Okay. And Harvey.
Harvey needs to be in the booth.
Okay. All right. You said Thomas is good now.
Yes. They just changed his sentence to credit for time served.
All right. This is who? Mr. Whitaker?
This is Mr. Jericho Marcel Whitaker.
Mr. Whitaker, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. Whitaker, you're before the court on state of Georgia versus Jericho Marcel Whitaker. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Lynch is with you. You're entering a plea to case 2024 CR 07496 for firearms discharge and reckless conduct. Mr. Lynch, what is your client plead to the offenses before the court?
Nolo.
To both counts?
Yes, Your Honor.
All right, to count two. So there was a count one, I guess, which goes with a co-defendant. There's count two is a nolo, count three is a nolo by entering a plea.
I think it's count one. From the accusation I'm looking at, it would be count one and count two, and the co-defendant is on count. Oh, I do apologize, Judge. I'm looking at this wrong. The accusation I have does not have numbers. I see count three, he's charged, and firearms discharge is the first one on the accusation, but it doesn't have a number.
Yeah, I just have a 2 and a 3. So that always indicates to me that somebody else has the other charge.
I apologize, Judge. You're correct. It just looks.
Okay, by entering a plea of nolo, Mr. Whitaker, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about September the 6th of 2024, Officer C. Joseph did issue a probable cause affidavit. Pursuant to the affidavit, the defendant did commit the offense of reckless conduct when he discharged a firearm in an unlawful manner. In discharging the firearm, he did endanger the safety of others in the area. Officer Joseph did collect 3 shell casings that matched the bullets in the firearm that was in the vehicle, and it was located right outside of the vehicle in which the defendant was sitting in. The defendant also committed the offense of discharging a firearm near a public roadway, in that the shell casings were located within 50 feet of the roadway. The defendant also committed the offense of discharging a firearm on the property of another, in which the defendant did not live on that property where the firearm was discharged. All of these events did occur in Clayton County, Georgia. Your Honor, for count 2, discharging a firearm, the state's recommendation is 12 months probation, a fine of $300 for the defendant to complete the gun safety course, and to forfeit all weapons. For count 3, a fine of $200.
All right, Mr. Lynch.
Judge, I've spoken to Mr. Whitaker about his rights in this case. He did indicate he wanted to go forward with the plea today. We would just ask that the court accept the recommendation from the state. The guns involved, I believe, did not belong to my client as indicated in the report, but he's not going to take any action to try to, get that particular firearm back. It's not his. And that's reflected in the police report.
So what was the point? What were we doing, Mr. Whitaker?
Ma'am.
Why are we out just shooting guns out of cars?
So before Mr. Whitaker makes any statements, Judge, I would just, and the police report reflects that the reason that both these individuals were arrested was that neither individual made any admissions about who was discharging the weapons. My client has entered a no contest plea today.
Okay, but this is what I would say. I'm not taking the heat for somebody else, but I'm not on the streets. So I don't know how it works. But if it's somebody else's guns and somebody else was shooting, I'm not taking the weight for it. I'm not wearing an orange jumpsuit, but that's on you. This is the other thing I say. If somebody will handle a gun recklessly around you, they will handle a gun recklessly towards you. And we have way too many people, kids and adults, who get shot every year because somebody is reckless with a firearm. I don't know, this TV or Call of Duty or all of these shows where it has y'all thinking that everybody can pick up a gun and know how to operate a gun just because you watched it on TV. Well, let me just tell you, their guns are not toys. And so when I see grown men handling guns recklessly or in a situation where guns are being handled recklessly, I just wonder, what are y'all thinking? Do y'all think the bullets just go out there and they don't hit anything? Or like if you shoot a gun up in the air, that bullet is just gonna magically go up to heaven? Because bullets come down at some point, and sometimes they come down on people and those people are killed or injured. So I just want people to have a different, I'm not saying people shouldn't, this is America. We have the Second Amendment. Folk have guns. I'm not saying don't have a gun. What I say is, if you choose to have a firearm, if you choose to use it, be responsible enough to take the classes, store it properly, and use it properly. Because the last thing you want is to be sitting in prison talking about, well, man, why are you in here? Well, I was just shooting and the bullet came down on somebody's, on a nursing mom while she was sitting on a park bench. You understand what I'm saying? Most of the people I see in your situation who are coming to me from the jail calendar, it's because they're making stupid decisions. That they're not thinking that next step. Like, if I do this, what's the next thing that could happen? How old are you, sir?
31.
How old?
31.
So you good and over the 20 stupid phase of life where you just doing stuff because your friends are saying it and it sounds like a good idea. You're in the phase of life now where you're supposed to be building wealth and making sure you have insurance and a car that works consistently. And if you got kids, looking over their homework or making sure they're getting the daycare on time. This is the phase you're in now, not the shooting out guns recklessly out the window to see what they can do phase. That's what the firearms places are for, where you go and you can like target shoot under safe conditions. We clear? All right. fussed enough at you, Mr. Whitaker. Hopefully from now on, you won't do anything dumb like this again. So this is, I'll accept your pleas of nolo for counts 2 and 3. I'll sentence you on on count 2 to 12 months probation, a fine in the amount of $300. It's going to be $444 with the surcharges. You're to take a gun safety course and present proof of having taken the gun safety course. Your firearms will be forfeited if you have any of your own, and also the one that was involved in this situation, you say it doesn't belong to you, so that'll be forfeited also. And on count 3, a $200 fine, $298 with the surcharges. Count 3 will run concurrent, meaning at the same time as count 2. So once you have completed all of the conditions of probation, so you'll have to complete all of the conditions of probation on both sentences during that 12 months. Okay. All right. All right, you can go back to the sheriff's office, Mr. Whitaker. Make better choices, sir.
Yes, thank you. You have to check in with probation. If they don't talk to you today, you're still on probation. Make sure you call them. They should be coming and talk to you.
All right, so now we have a bunch of petitions in the McDowell case. So are we ready on the petitions? Well, Mr. Somebody's talking to McDowell, Mr. Taylor. Can we move forward on Agwu, Cafe, Harvey, and Wilson?
We're on Harvey. We're ready to move forward on McDowell.
Okay, we're on Harvey.
And we're also ready on Wilson.
Right.
And I think we still need to speak to Mr. Harvey. Is that right?
I've spoken to him. We're ready.
Oh, we're ready. I'm sorry. We're ready on Harvey as well, Judge. I apologize.
All right, I'm ready.
Sorry, guys. Yeah, I still hear.
Probably.
And then Agwu, I think, also not represented, but he's also ready, Judge.
All right. Ms. Val, for Mr. Brown, can we just go ahead and send him notice for October 8th and I guess we can require him to be here. I'm trying to remember. I think he was local. We can require him to be in person.
Judge, who would you like to go forward on?
Whoever y'all put in front of me.
Pull up Mr. Agwu.
Mr. What?
Agwu, probably pronouncing that not right. Correct.
Is that who y'all have coming up?
Yes, Judge.
All right, bring him up to the computer.
Right there.
All right, so, Mr. Aglu, Bashar Terrell Aglu, you're before the court on 2023 CR 11258. You were before this court on, January 9th of 2024. You were sentenced to 12 months on probation for simple battery, family violence, 2 counts, and it says that you violated the criminal law by getting arrested for a criminal trespass, 2 counts, cruelty to children in the third degree, battery and obstruction or hindering a law enforcement officer, 6 counts, on September 7th of 24 in Clayton County, Georgia. I'm hearing a lot of static. So is that me or is that sounds new?
That's Mr. Austin.
Oh, that Miss Martin, I figured you would know.
I
Okay.
do.
So, Mr. Austin, I'm gonna mute you for a second, okay? So, failure to report, he has failed to report on August 19th and August 29th of 2024. He last reported on July 29th of 2024. He has failed to provide proof of enrolling in the Family Violence Intervention Program, and he's failed to pay these $200 in arrears. Mr. Lynch, or is it Mr. Taylor? I'm sorry.
Thank you, Your Honor. I believe Officer Austin spoke with Mr. Agwu earlier, and they had come to a
Oh, I'm sorry, Mr. Austin, what is the recommendation?
Your Honor, recommendation on this case is to serve 3 months and close this case.
I'm gonna need him to serve the 3 months and 15 days.
Yes, Your Honor. Revoke the balance.
Yeah, we're gonna revoke the balance. And Mr. Agu, you can expect a revocation, a bond revocation, a motion to have bond revoked on your new cases, which are gonna come before me. So I'll expect for the state, to go ahead and send that bond revocation, motion.
Yes, Your Honor.
All right, so Mr. Aglu, we're not gonna talk much about your case. You're clear on what my requirements were for the bond conditions, where you're not to have any additional charges and you're not to have any violent or harassing contact with a named person. In this case, you have picked up charges of a violent or nature. I'm not sure who the alleged victim is, don't need to know that right now, but it does trigger the fact that there's a potential bond violation. So I expect to hear the bond revocation motion on the new charges. I'll sentence you, I'm going to revoke the 3 months and 15 days that you have remaining on this case. And then I will see you back here for the adjudication of the pending matters. Okay. All right. You can go back with the sheriff's office. Anything else? Okay, we're good.
No, Your Honor. Thank you.
Oh, Mr. Austin is also going to be day for day.
Copy that, Your Honor.
Can we bring out Mr. Harvey? Yeah. Your Honor, we'll bring out Mr. Harvey next.
That's fine. I hate this application. I got the whole thing filled out and then it just disappeared when I switched to signing. Hold on just a second for me, Mr. Harvey. Let me get this recorded before I can go to your case, okay?
So that's what they say that you failed to do. You owe $990. You tested positive for alcohol. And revoke 11 days, correct. Since 9/13, today's the 24th, and return to probation. So it means without today, check with Ms. Chang to see when the next report date is, because you don't want to say. No, I definitely won't. Yeah. So that's what it is. It's the same. Yes. So I gotta ask Ms. Chan for her to release or pay the bond. You can ask her. She told me before, she said she was as a judge for you. Well, you do, you complete everything that you need to do, and you ask her, and then she gets before the judge. The judge makes the ultimate decision, but she has to make the request. Okay. That's a great beer. Yeah. Me too. You too. Yeah, right. What's going on?
All right, so Ava was on his way over. Harvey, Ms. Chang. Mr. James Horace Harvey Jr., raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So, sir, you're before the court for a probation of revocation. You were before this court for driving under the influence on the 22nd day of January 2024, sentenced to 12 months on probation. You have 3 months and 27 days remaining. Your sentence was not told. You failed to avoid injurious and vicious habits on August 27th of 2024. You tested positive for the metabolites of alcohol, and you failed to pay your $999 in arrears. Mr. Taylor?
Yes, Your Honor. We stipulate to the violations of probation, and we also accept probation officer Chang's recommendation to resolve this matter.
All right, Ms. Chang?
Your Honor, probation recommends that 11 days be revoked, credit for time served since September the 13th, return to probation under the same conditions, and test each report.
All right, so Mr. Harvey, let me tell you why she's making that recommendation.
Yes, ma'am.
Mr. Harvey, we may have already had this conversation, but you are an alcoholic. You have an addiction issue, and an addiction issue is a medical condition. And so when you would jeopardize going to jail rather than taking drinks of alcohol, that tells me that your body craves alcohol more than it craves freedom. Can we agree?
Ma'am, I'm not an alcoholic. I made a mistake and I apologize for that. And I realize
Mr. Harvey,
Yes,
let me
ma'am.
tell you what I think is an alcoholic, and maybe our definitions differ. But
Okay.
you're before me for a driving under the influence case, which means you were drinking and driving, putting other people's lives in jeopardy. Now, that case, we've resolved it, and I said, as a part of your sentence for the next 12 months, you're not to have any alcohol or illicit drugs. That's the way I say it all the time. So I know you weren't confused.
Yes, ma'am.
But what this tells me is that with 3 months to go, your body craved alcohol so much that you were willing to risk it. And it also indicates to me that because the testing is random, you've probably been drinking at different points during your probation. We just haven't caught you. But the fact that what is scary to me is the fact that you don't think you're an alcoholic, which means that when you finish with this sentence and you're no longer under a restriction not to drink, you're going to go right back to drinking. When you don't understand that you have no control over your addiction. Do you have a job, Mr. Harvey?
I do.
I'm sorry?
I do. I work for a construction company.
Okay. And are there construction projects going on right now?
Yes, ma'am.
And could you be making money?
Yes, ma'am.
But you're giving that up because you decided to take some drinks and now you're in the jail for at least 11 days missing work.
Yes, ma'am.
Would you willingly miss work?
No, ma'am.
Do you willingly give up money?
No, ma'am.
But for alcohol, you did. You see what I'm saying?
Yes, ma'am.
Is it making a lot more sense now?
A lot more sense.
Okay, because everybody's first instinct is to say, I'm not an alcoholic. No, no. But my view of alcoholism is when you lose control of your life, and especially when you end up before me, um, and you're not able to control your craving for alcohol to the extent that if somebody told me, Judge, you can, as much as I love coffee and as much as I love chocolate, if they said for the next 12 months, if you have coffee and you're gonna go to jail, well, I would switch to tea. Or I would switch to sodas or something, but I'm not drinking coffee because I don't want to go to jail. I don't want to lose my job. I don't want to miss money. I don't want to miss time with my family.
Yes, ma'am.
But I told you, don't have any alcohol, and you were like, yeah, but I got to risk it.
No,
It doesn't matter the circumstance.
yes, ma'am.
Doesn't matter whether you were drinking with friends or you had a stressful day and you just decided to grab a beer, whatever story you tell me,
Yes,
it's still a violation of what I asked you not to do.
yes, ma'am.
And so these 11 days, I hope you have thought about this,
Oh, my God.
and I hope you think about it going forward. Ms. Chang, is he doing AA meetings?
No, Your Honor.
Okay, so you have, and let's see. So you have 3 months and 27 days remaining. You're gonna do you've done these 11 days. Like I said, it's expected. Whenever somebody has an alcohol problem, I expect that they're gonna mess up because you cannot not mess up. You're an alcoholic, your body's craving alcohol. But what I say to you is this is a wake-up call for you. So if somebody ever asks you, are you an alcoholic? You now know that you have an addiction and you are an alcoholic.
Yes,
It's as simple as that. But as I say, it's just like having high blood pressure or diabetes. It is something that if you don't treat it and take it seriously, it will destroy or end your life. And I can't make you understand that any more than standing in an orange jumpsuit, missing 11 days of your life, missing work and missing money and missing time with your family. If that doesn't tell you that there's an issue here and having risked other people's lives by getting a DUI, if that doesn't tell you there's an issue, there's nothing I can do to help you. What I'm going to do is return you to probation, but you're going to have the added condition of 2 AA meetings per week.
yes, ma'am.
And I saw you drop your head like that's something to be ashamed of.
No,
But AA is a group of people who have the same issues, who support each other in recovery. And 2 meetings a week is less of a strain on your time than sitting in the Clayton County Jail would be. Now, I could put you in jail for the remainder of your sentence, which is 3 months and 27 days. Or you could do these 2 meetings a week and show proof of having done that and be out to work and to be a part of your life. So you tell me which you prefer.
I prefer what you would suggest, Your Honor.
Okay, let's see how this works. All right. So now I'm going to accept your plea to the probation, what probation has told me happened. I'm going to give you 11 days and give you credit for time served for those 11 days that were revoked. And I'm going to add the condition of 2 AA or NA, so that's Alcoholics Anonymous or Narcotics Anonymous meetings per week. And you're to show proof of having completed those, as well as any other outstanding conditions that you were to complete. You'll still have to do those, okay?
Yes, ma'am. Well, Your Honor, is this every week until the probation is over? Like,
Yeah.
yeah. So it's- yeah.
Yeah, until probation is over. Sir, I can't tell you how seriously I take this because
Yes, ma'am, I see how serious you do, and I really understand these 11 days has been like 3 months in that side. So I mean, I've seen all the bells and whistles of everything that was totally wrong about this situation. So I do understand.
All right, just trying to get these get this autofill to work correctly. All right, so sir, I'm going to return you to probation under the same conditions, but the additional condition of 2 AA or NA meetings per week, and you're to show proof of that to probation. All right, Mr. Harvey, think carefully about how you want the rest of your life to look, okay? And think carefully about the fact that you should never jeopardize someone else's life and safety because of your addiction.
Yes, ma'am.
All right, you can go back with the sheriff's office.
Your Honor, may I give him his next appointment?
Sure. Thank you, Ms. Chang.
Mr. Harvey, if you'll report next Monday, September 30th at 1:30 to our office.
Yes, ma'am.
All right, next.
Thank you, Your Honor.
You're welcome, sir.
Mr. Wilson, I think is our last,
No, Kathy.
oh, I'm sorry. My apologies. Judge, did you want to do Kathy first, or can we go ahead and do Mr. Wilson?
I don't care. Whoever y'all put up there, I will find it. I'll meet y'all where you are.
Thank you, Judge.
Mr. McDowell is an actual.
Yeah, we haven't heard from McDowell. Is that a plea or what we doing with McDowell?
That's a plea, Your Honor.
Okay. All right, so whoever y'all bring, just let me know who it is.
And in the matter of Mr. Caffey, he's picked up new charges. Has the state accused those charges at this time? I believe it's a public indecency charge. He's on the calendar for VOP last week. We continued him this week. He was acting.
Are there, okay, so we're dealing with public indecency. Are there concerns?
When he's in custody and seems to be getting medication, he seems to be okay. He's certainly competent enough to understand what he's accused of. Once he's released, then he acts erratically again. When we first spoke to him last week, he was acting erratically here at the courtroom. That's when we asked to continue that particular hearing. After a week in jail, I imagine he is probably a little closer to his his regular state rather than his erratic state.
Okay.
And I just asked so that it may be possible that we resolve both the probation matter and the new charge matter, if that's possible.
If it's possible, I don't have a problem with doing the resolution of both.
If the state's not ready to move forward on the other charges, then we can just handle the VOP issue.
Okay. All righty.
Yeah, I don't have the other charges in front of me, Your Honor, so.
Okay, are we ready to go forward on the one that we have now?
We need Mr. McDowell and Mr. Wilson.
And Mr. Caffey.
And Kathy. I think those are the three remaining on our calendar.
Deputies are just, the current deputy is trying to grab the key from the other deputy. So here, Mr. Wilson.
An actual case, and it's an abandoned thing. Start calling out of that. Yeah, that's true. That's good.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. Who is this gentleman?
Judge, this is Joseph Demond Wilson.
All right, so Mr. Wilson, you're before the court for a revocation of probation. Mr. Wilson, you're before the court on State of Georgia versus Joseph Demond Wilson, 2024 CR 06690. For you were before this court for simple battery, family violence, under first offender criminal trespass on the 13th day of August 2024 and sentenced to 12 months on probation. You have 10 months and 18 days remaining. Your sentence was not told. You have been arrested for criminal trespass. I'm sorry, for terroristic threats and acts on September 13th, 2024. You failed to avoid injurious and vicious habits. You had violent contact with Tiasia Shanice Stewart, or a member of the victim's family on or about September 13th of 2024. You failed to complete proof of enrolling in the Family Violence Intervention Program, and you failed to pay. All right, Mr. Lynch.
Judge, we'll stipulate that he was arrested for a new offense. We're not making admissions to the underlying charge there.
Okay.
Do stipulate that he did not register for the FIT program in time as directed, although he did have very little time to do that.
All right, what about the contact?
So that, I believe, stemming out of the violation of criminal law, Judge. We're hoping we could just stipulate to the fact that he was arrested for an offense rather than that.
Because this chart is separate on here.
And I see that, Judge. But with our stipulation to the first initial and the rest, does that give the court enough to go forward? I mean,
right, but it may not be what you agreed to.
Well, hold on.
I mean, I'm not asking him to jeopardize his defense, but what I'm telling you is, based on what I'm seeing, even if I took the arrest off, then the other one is going to give me pause. And so.
Well, so, I mean, we will stipulate, of course, to the fact that there was contact, not the fact that there was a criminal offense.
That's fine. All right.
We're hoping you're going to take the recommendation, of course.
What's the recommendation, Ms. Chang?
Your Honor, probation recommends that 90 days be revoked, credit for time served since date of lockup, September 13th, and close the case.
No, revoke the balance.
Judge, given that you're not going to accept the recommendation, can I at least have an additional conversation with my client about what?
Sure. Tell him I want 10 months. Yeah, that's the conversation y'all need to have. And since this is a probation revocation as opposed to anything else, it's likely that I'm going to get what I asked for.
I understand, Judge. Could we have Mr. Wilson back in the booth so I can give him that advisement?
All right, who's next? Well, I can wait until y'all talk to him, but it should be a short conversation. I want the balance.
We bring up Kathy or Miguel, either one. You said who? Kathy, Thomas Kathy. That's an older man. It's on the that's okay. Let's bring up Miguel. He should still be in there. Bring him up here? Yes. Your Honor, deputies are telling me that Mr. Caffey was not brought up today, since the recommendation would still extend his time in custody. Since the recommendation from Officer Chang would extend his time in custody at least additional week, we'd ask that this be moved forward to next week's.
That's fine. We can move it. Is this Mr. Caffey?
No, this, Your Honor, is Mr. McDowell.
Okay, we're ready on a plea for McDowell?
That's correct, Your Honor. We're entering a guilty plea to the single count of abandonment and accepting the solicitor's recommendation.
All right. Raise your right hand for me, sir. Solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. McDowell, you're before the court on State of Georgia versus Mr. Devin Devon McDowell, 2024 CR 07616 for abandonment. You're represented by the law firm of Lister Holton Dennis. Mr. Taz Taylor is with you. Mr. Taylor, what does your client plead to the offense of abandonment?
Your Honor, my client is pleading guilty at this time.
All right, by entering a plea of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about August the 7th of 2024, Miss Patricia, Patricia, Miguel, Miquel Withers, Withers, did take out a state warrant for abandonment against the defendant. Pursuant to the warrant, the defendant willfully and voluntarily left his minor child in a dependent condition by failing to furnish sufficient food, clothing, shelter, or medical care for a period of 3 months. The name of the child is Josiah, Josiah McDowell, born in 2011. The affiant, Ms. Withers, is the aunt of the minor child. Your Honor, the state's recommendation at this time is 12 months to serve, 48 days, balance suspended, and under the special sentencing provision of OCGA section 19-10-1J, the sentence will be suspended until the victim turns 18. We're also asking for, pursuant to Ms. Withers, we're requesting no contact with the minor child, as well as no contact with Ms. Withers. And she is also on the line and wishes to give a victim impact statement as well.
I will say, Your Honor, that the no contact provision between Mr. McDowell and his son was not presented to the defense prior to just now. Mr. McDowell had been caring for his son. The mother of his son is in prison. So the son has been in Mr. McDowell's custody due to housing situations. Mr. McDowell recognized that he may be better off living with his aunt, who is the mother of the child's sister, and he voluntarily relinquished custody. I don't know if that's in a legal fashion or just go with his aunt. I do want the judge and the court to take this into consideration, that he has been providing for his son and been the sole support, but understanding the situation and what's best for his son and his son's education, which his aunt would be better able to provide him a stable housing location, which meant a stable school environment as well. He voluntarily did that. So we understand his aunt is concerned about monies being provided while she's taking care of the son. However, we don't feel that Mr. McDowell's done anything inappropriate that would cause no contact provision to be
Hold on, Mr. McDowell. Let me hear Ms. Withers. Ms. Withers, I need to see you and hear you, please.
Yes, ma'am, I'm here.
All right. Let's see. All right. So Ms. Withers, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. So Ms. Withers, abandonment cases are kind of unique in the sense that we're criminalizing a parent's failure to care for their minor child. So usually what is not a part of it is a no contact provision because we're usually begging them to have contact with their child to provide the intangible support, not money, but things like emotional support and, the love and care that a parent is supposed to have for their child. Um, Tell me your views on this situation. And I know the dynamics are um, kind of extreme in the sense that your sister is serving time and then now um, Mr. McDowell has indicated that he has issues that make him unable to care for a 13-year-old son, is it?
He's 12. He'll be 13 in October.
Okay.
Yes.
All right. All right. So tell me what's going on, Swivers.
Yes, ma'am. Well, good afternoon, and thank you for Your Honor for allowing me to speak on behalf of myself and my nephew Josiah McDowell. My name is Patricia Withers. That's Patrecia Withers. And since Josiah may not be allowed to speak, although I have him in the other room in case he needs to, I will gladly speak up for him. Your Honor, I have taken care of Josiah since the day he was born. I was at the hospital, picked out his name. I've been caring for him for all of his life, whether that was providing necessities for him that his parents could not give him or being there for guidance and support. I've helped with schoolwork, went to all his graduations, been there for birthdays, holidays, while they were in and out of jail or absent, and kept him for several years without receiving any financial support or emotional support from his parents. And to be clear, Josiah was physically under Devin McDowell's custody, at least for the last 2 years or so. But I would get Josiah every other weekend, all of his school breaks, and for the entire summer. And during all of that time, Devin McDowell barely reached out to speak to him nor check up on him. I went to his graduation for 5th grade, and although Devin McDowell lived within 10 minutes walking distance, he didn't show up. He refused to show up. After moving in with me, this most recent time, Josiah has informed me of several negative occurrences, one being that he was mentally abused or bullied almost daily by Devin McDowell, and he was also physically abused. And Josiah has told me of an incident that his father, the person that's supposed to take care of him and provide a safe space, he put a pillow over his head in attempts to get rid of my nephew. And because I believe that Josiah was simply too much of a burden for him to have around, I say those accusations are allegedly simply because we're in court. But I didn't see it with my own eyes, but I don't believe my nephew would lie about something like that. My nephew also informed me that Devin McDowell has told him several times that it would be better for his family with his current girlfriend, who also abused him, and her 2 kids if Josiah was not around. So I wasn't surprised when the police contacted me several times one day to inform me that Josiah was in an unsafe environment. It was a flooded basement. He was left alone several times to the point where even the other people living in that house threatened to call the police on David McDowell for leaving him alone down there, and I needed to get him. This is what the police told me. And I say that I'm not surprised because Devin had been trying over a year to convince me to take Josiah and just put him on child support so that he wouldn't have to deal with him. And Josiah has lived with other people, including strangers in the neighborhood, that he paid to stay with them.
I have this thought theory, and it's just my theory, that one of the most important things for a developing child, especially in the adolescent age range, is stability. And it seems that this young man has had a very serious lack of stability. how is he doing in school? How is he doing from your standpoint emotionally?
In school, Josiah's always excelled in school. He's always been on the honor roll and everything. Uh, as far as emotionally, I don't think he's doing that well. He doesn't really, even when he told me about the incident, it was so, he said it in such a calm manner, like it was shocking to me. I'm sorry.
Disconnected, because a lot of times what happens is when people experience any form of trauma, then they have what's called disassociation, where they will recount it calmly to someone else because they're pulling away from it emotionally.
Yeah, it was just sad for me to hear it, So
are you seeking any kind of legal relationship with with the young man beyond just having him in your care? Are you seeking a legal relationship with him?
Well, I'm going to court. I'm currently in court for the guardian ad litem, and I believe they're going to, I guess, determine if Josiah is going to live with me permanently with that guardianship. As far as anything else, when Josiah was given to me, he offered and signed a power of attorney stating that he would pay $150 every 2 weeks for Josiah. His girlfriend sent me $100, I'm assuming on his behalf, one time, and then he was forced by the Honorable Judge Wright Hill to give me approximately $500 in July. He didn't show up for the next appearance to avoid paying the remaining amount. And I've had Josiah for over 6 months so far, and I've not received any support outside of that for him. And Judge Wright Hill also asked that he call Josiah directly, but he only called him like 3 times around the end of June and never heard from him again. And he was out during that time period. So
there's a pending case in juvenile court?
Yes, ma'am.
Okay. All right. So anything else, Mr. Taylor? Any questions that you have for Ms. Withers?
I'm just a little confused to why she's trying to keep Mr. McDowell out of his son's life, and yet she's claiming that he's abandoning his son. It looks like
the two things they can happen at the same time. One, because based on her testimony, there seems to be a lack of stability.
Absolutely. We do not deny that there's a lack of stability, and that's why Mr. McDowell turned over custody of his son to his aunt.
But his son has also recounted some disturbing allegations that would constitute either neglect or abuse if proven. And so maybe that's why she's asking that he not have contact.
Well, certainly. However, those are allegations. This is the first I'm hearing of these allegations. And
well, you expected Mr. McDowell to tell you?
Well, I don't exactly trust Ms. Withers to tell me accurately either.
Well, of the two of them, I think that Ms. Withers is the one who's showing up. And I hate to say it, but of the two of them, Mr. McDowell trusted her enough to take care of his child, because as you indicated, he willingly gave her the temporary, in whatever sense, custody of his child and trusted her to care for this child. And so
that's correct, Your Honor. I would suggest to the court that if the court's concerned about the young man's emotional well-being and growth, that his father remain in his life in some fashion. And
well, Mr. Taylor,
even if it's under the
having done this long enough and having done exclusively, I mean, having done abandonment as part of my jurisdiction as a magistrate court judge, I can tell you that sometimes a parent's presence is more disturbing to a child than their absence. And in that sense, I mean, if it's going to be a situation where it's a back and forth, a pulling, a pushing, statements or actions that make the child feel insecure or unwanted, then it is what the court deems is in the child's best interest that matters. And so in this case, because I'm not that deeply ingrained in the facts of this case, but from what I'm hearing, I don't think it's unreasonable to let the juvenile court make a determination about Mr. McDowell's role in this situation from the standpoint of the abandonment. It doesn't appear that he's been there. He may have turned this child over willingly, but he's entering a guilty plea. Ms. Withers has testified that he was made to pay $500 by Judge Wright Hill, that his girlfriend paid another $100, that the police contacted her to come get this child out of a situation. And so I just would rather have the juvenile court make a more permanent decision. But with respect to what's being requested by me now, until the juvenile court makes a different decision, I'm fine with the no contact provision.
Your Honor, my concern is that your no contact provision with the sentence today will be used against Mr. McDowell at the juvenile courts. The reference book was a state court judge found it appropriate to assign Mr. McDowell no contact provision in an abandonment sentence. Then who are we as the juvenile court to say that is an incorrect decision? We want to be consistent with the state court and would continue to impose such sentence rather than make it an independent determination. I just feel that Mr. McDowell supervised visits, I think would be acceptable. Supervision by
No,
Withers.
I'm not putting that burden on Ms. Withers, because that's a burden that comes with that there's some issues with supervised visits, because then I got to figure out who's going to supervise them, and if it's some third party that costs money, and he already is not paying, so I'm not going to impose that burden. This is what I will say: does the young man have a phone, Ms. Withers?
Yes, ma'am. He has a phone. I gave Devin McDowell his direct phone number. That's why, as I stated previously, Judge Wright Hill told him that he should call him. He called him a total of 3 times and hasn't heard, Josiah hasn't heard from him in months.
All right, so this is what I will direct. Mr. McDowell, you can text the young man, which will leave a record. That is the contact that you are allowed to have with him, text messages only. And so these messages will be reviewable by the juvenile court, and the amount of messages, when those messages come in, whether they're positive or negative, those are all things that the juvenile court can review. Mr. Taylor's concern is that the juvenile court may just rubber stamp my decision. I know those judges, and they ain't scared of me. They have their own jurisdiction. And so I'm clear in my mind that they're not going to rubber stamp. But I will clearly, I will make it clear in this sentence that I will accept your plea of guilty. You're sentenced to 12 months to serve 48 days. The balance will be suspended as long as the only contact that you have with Josiah McDowell is by text message to the phone that he currently has and the number that you were previously given. Those text messages will be reviewable by the juvenile court, and the juvenile court can make whatever determination it feels appropriate for the continuation of any contact that they may order with the minor child. With respect to Ms. Withers, the only contact that you will have with Ms. Withers is to send money orders. So they can be postal service money orders or Western Union money orders, or wherever people get money orders that are reliable. The only contact you're to have with her is to send money orders in the amount of $150 every 2 weeks. A failure to send those money orders will put you in jeopardy of coming back before this court for failure to complete a suspended sentence. And sir, your sentence will be suspended and pending until such time as this child reaches the age of majority. The child is not yet 13. So that's a good 5 years that you and I are going to be talking about your care and concern for your minor child. Ms. McDowell, let me just tell you something. Kids don't ask to come here. Condoms are cheaper than child support or child care. And so when you bring a child into this world, you make the decision that you're going to work as hard as you possibly can. If I got to have 3 jobs, if I got to walk around clearing out people's garages and doing yard work, if I got to work 3 jobs at a time to care for the child that I brought into this world, then that's what I will do. But you can't rely on your girlfriend to pay for your child support. Your girlfriend has her own children, and she didn't lay down with the mother of this child and have a child. And so that is your responsibility. And so stay out of an orange jumpsuit, work as hard as you can get, even if you got to work 3 jobs to make sure that you pay for this child, and show him what a man looks like, Mr. McDowell, somebody who cares for the people that they bring into this world. You can't just give Miss Withers your child and say, well, I can't take care of him, I'm gonna give him over to you. Because you know what that says is that you're irresponsible. When you bring a child into this world, your commitment is to that child as long as you are in this world. And so when a custodial parent, which Miss Withers is now the custodian of your child, she doesn't have the ability to say, well, I don't have it, I can't provide it. Because then that would leave your child in the system. And you would have a fit if Miss Withers was like, well, I'm just going to kick him out on the street because I can't feed him today. But that's essentially what you're doing. You're not feeding your child. You don't know if he's eating every day. You don't know if he's going to school. You're not sitting down doing homework with him. When he gets sick, you're not up making sure he gets to a doctor. You are not doing any of those things that a father would do. You're not showing me father. And so when Mr. Taylor says, well, Judge, I don't think you should interrupt the relationship between a father and a son, you don't have one. Instead of buckling down and doing whatever it took to take care of this child, well, Miss Withers, I mean, you might as well take him. Thank you for that, though, because at least he's got a shot at growing up to be a child who is not mentally messed up. But get yourself together, sir. Get yourself together. Prove that you deserve to have him in your life. Because he sounds like a remarkable young man. With all the instability that y'all have, he's still a great student. He's still focused on getting the job done. Way more focused than you are. We clear? Have I made myself clear?
I'm clear on you, Your Honor, but last statement, you could let me talk, she's a liar.
Sir, the fact that you gave your son to her to take care of tells me that you probably need 2 more jobs than you got. We clear?
I'm clear with what you say, Your Honor.
All right. So do what you said you were gonna do and send that $150 every 2 weeks.
It ain't no problem. That's all she want anyway. She getting channel on it.
Well, you can talk jiggy with it if you want to, but you ain't showing me nothing. Show me. Show me that you're the man you're supposed to be. Show me that you're the father you're supposed to be. You can say anything. Most people do. But you're the one in an orange jumpsuit, sir, and she's taking care of your child. And until you can express to the juvenile court at least that you can take care of your child, you ain't doing nothing but talking. Talking loud and saying nothing. James Brown, check him out. All right, you can go back to the sheriff's office. All right. Who we got next? Oh, we still on Mr. Wilson. Come tell Mr. Wilson I want my 10 months.
Yeah, he indicated in light of that he would like a evidentiary hearing on the alleged violation.
All right. He's gonna be in jail until such time as the police and whatever witnesses the state and Ms. Chang want to bring. Ms. Val, what's the next Tuesday hearing?
October 8th. You want
All
something
right.
after?
Evidentiary hearing on October 8th.
That's understood, Judge.
But tell Mr. Wilson that once that testimony is on the record, it will be used against him in whatever subsequent proceedings. And he's got to come back before the court for all of those charges, this court. All right. So if he's mindful for that, then I'm fine with it.
Yes.
Also, because he's picked up the additional charges, there may be a motion for revocation that should be filed at this point.
Well, what's a,
Well, what's
you mean a motion to revoke his probation? Because it's not a, my understanding is the motion would be to,
motion to revoke bond.
Oh, I understand what you're saying. Okay, I understand.
So, to clarify, because I had some issues with the state getting to the point of trial and then doing motions to revoke bond. That's not the time. When somebody gets arrested and it's jeopardizing a probation that they're already on, or they already have a case for bond and they come up on an arraignment on a new case, well, that to me is the perfect time to ask for a motion to revoke bond, because don't mess with my cases once they get to the trial phase. But if we're in the arraignment phase or there's a bond revocation, then by all means, you can ask for a motion to revoke bond. That's the appropriate time. So tell Mr. Wilson he also faces a potential motion to revoke bond.
I will make him aware of that, Your Honor.
Thank you. And also remind him that they listen to jail calls. So if he messes up and makes even more contact, that's going to be even more of a problem. Yeah. Since he's about to ask for a hearing, I'm warning him against witness tampering.
Yes, Judge. I will tell him that now.
Thank you.
Thank you, Judge.
All right. Anybody else? I think that is it.
Your Honor,
yes,
I have
Chang?
a question about Mr. Caffey's case.
Yes, Ms. Chang. So my understanding is, Ms. Chang, he has another case that hasn't been accused yet, and they're trying to wait until that one gets accused.
And I believe that's the nature of violation that Officer Chang is revoking the current case on, is the arrest on public indecency.
Right. So what else? Did you have another question, Ms. Chang?
Yes, ma'am. What date will that be?
He's set for the October 8th one, but if you all need more time, let me know and then I can move it.
No, Your Honor, that's fine. I just understood that it was going to be for next week, and there's no arraignment for the 1st, so I wanted to make sure.
So the October 8th calendar, y'all be ready for a hearing. So the state may have to bring some people in for that, but we'll have the full hearing for the revocation.
Okay.
Your Honor.
Thank you, Your Honor.
Yes.
Charles.
Thank
Wise,
you.
for the PM calendar.
Okay,
Are you seeing him today?
Who?
Charles Wise.
Charles who?
He's at 1. He's at 1.
Yeah, he's at 1. That's the 1 o'clock calendar. It's 12:44.
Okay, I just want to make sure.
Yeah, no problem. So we're gonna adjourn the jail calendar, but we'll be back at 1. I'll leave the calendar up. I'm gonna leave it up. I'll just stop the recording until we're ready to record for the jail. For the 1 o'clock calendar. All right. So we'll be back. Is there anything else on this jail calendar or the arraignment calendar?
I do not believe so, Your Honor.
Oh, Your Honor.
All right. So we'll be back at 1 for the 1 p.m. calendar.